Alex here with part 2 of the Corazon real estate series. As with my previous video, please take a look at part 0 if you haven't seen it yet. Even though part 0 talks about the child custody case, it still kind of follows, or it still kind of applies in the sense of the educational purpose of these videos. I'm using these videos to show people by example, by covering every single filing and every single hearing in this case, sort of what to expect when you're representing yourself and stuff like that. So same principles apply even though it's not a child custody issue. First thing I want to mention is I recall filing a ex parte temporary, or what is it called? Ex parte temporary restraining order request. This is not like one of those domestic violence protective orders. It's different. The temporary restraining order is something that the court can issue prior to a preliminary injunction, and then an injunction is something that stops a certain party from doing a certain thing based on an order of the court. There's more details on how these work in the video injunctions. I believe that I was trying to do this to get the landlord to stop efforts to evict me from my apartment at the time. This wasn't the right approach. I'm pretty sure it wasn't the right approach, and I'm pretty sure that I know why I tried to do it this way. So the justice courts in Nevada, for the most part, handle these residential summary evictions, and that's what happened in my situation. If you watched part 1, you'll know the underlying facts. I'm not going to repeat them now. Definitely watch part 1 or you're not going to have a clue what's going on. In any event, the justice court stated that, or the justice of the peace stated that his decision was unappealable. Now, I don't think that I believed that at the time. I'm still going to explain it because just in case that might be why I tried to do it this way. This particular judge was, and I found this out later, I didn't know this at the time, he was relying on a rule. It was JCRCP 106, which did actually say that summary eviction orders were not appealable. There was a rule that said that. The Supreme Court of Nevada struck that rule down as unconstitutional, and I just think he just didn't know. I don't think that he was acting malevolent, against me. I think he was just incompetent, didn't know what he was doing. He was a senior judge, so he probably just stopped checking updates on the law, and he just probably had no clue that court rule was stricken. So I think that he told me that because he thought that was still the law when it really wasn't. Anyway, I still think that I knew that at the time. What I didn't know was that the hearing wouldn't be recorded. This is why I think I didn't challenge the decision, because I didn't have a way to get a transcript. My suspicion, that's only my suspicion. For all I know, that wasn't even what I was thinking either. The appropriate way, first off, I should probably tell people, some courtrooms don't record their hearings, which means you won't be able to get a transcript, which means you may not be able, in fact, I'm going to change that to most likely will not be able to appeal the decision. In fact, it's because of this particular experience that I created the video. Court reporters actually warn people in that video, make sure the hearing is recorded, because if it's not, you better get a court reporter to go. I found this out, and then later on at different hearings, I actually did have court reporters come. But that one particular crucial hearing, I didn't know that. I just assumed everything was recorded because I'd been in family court for years and everything there was recorded. So bad assumption. Anyway, had it been recorded and everything was done correctly, then the correct response would have been for me to file a notice of appeal from the justice court to the district court. And then the district court can make the decision on the appeal. If the district court rules against you, then you can file a petition for writ of certiorari to the Supreme Court. That's got all kinds of complicated things behind it. Please watch my video on the topic writ petitions to learn more about how that works. In any event, my approach, either it was an end run or I just didn't know that I could, follow that all the way through, or it was because I didn't have a transcript. Anyway, my approach was to try and get an injunction to block the eviction. So I don't think that this was the right way to go. My mindset at the time was obviously very frustrated because to me it was clear you shouldn't be charging people to fix the AC and stuff like that. Normal landlords don't do that. Why is this landlord doing what other landlords don't do? And that's just kind of my sort of recollection of my mindset at the time, which is that the system isn't unfair, and what can you do, right? Hopefully people can learn from this video and what I was trying to do in this video, and hopefully it actually helps people, even though I think it's the wrong approach, kind of explains my thinking and what I should have done. In any event, let's go ahead at this point and take a look at what I have filed. we have the ex parte motion for temporary restraining order. If you guys haven't seen it yet, please watch my video on the topic ex parte perils. In this particular situation, this is the way you're supposed to file it. You're not supposed to give the other side notice. So, anyway, ex parte, and this is explained in the Rules of Civil Procedure. And in fact, guys, I'm pretty sure I have a video on the topic temporary restraining orders. I'm 99% sure that I do, and it would be under the legal nuts and bolts category. In any event, let's go ahead. A standard introductory paragraph. I'm indicating that I am appearing in proper person, which means representing myself, and that I'm filing this particular motion. Factual background. So let's see here. I directed a process server to serve the notice of failure to maintain to the landlord. On September 1st, the landlord rendered repairs to the toilet and I contacted them regarding a rent credit in accordance with the law. Landlord replied that it would evict if rent was not paid. This is a very common strategy for landlords. There are laws that allow you to withhold rent if certain things aren't done in a certain amount of time. In Nevada, 99% of the time, if you say, to your landlord, this law says that I don't have to pay rent, they're just going to say to you, we're going to evict you. Most of the time, that's what they say. You just have to expect it right up front. They want their rent check. If they didn't comply with the law, they don't care. Most of the landlords feel that the laws apply to you, but not to them. It's just the honest truth of how it works in this state. I had rented for so many years, and this was a very common pattern. I had never seen a landlord say, you know what, you're right. They just don't do that. And I think they don't do that because it works. I think that you give them 1,000 tenants and you say, you're going to evict them for whatever reason, and 999 of those tenants are going to say, okay, I'm going to do whatever you want, because they don't want to get evicted. Maybe 1 out of the 1,000 will challenge them on it. And it's a sad reality, but because it's such an effective terror tactic, and I do use the word terror because that's what it does. It terrorizes people. Under the punitive damages statutes, they call it oppression. In any event, because it's such an effective tactic, they continue to do it. If it wouldn't work, they would stop. That's my belief, is that if they tried to do this and it didn't work, they would stop doing it. And they only continue to do it because it does work. And I'm really not picking on Corazon Real Estate. Every single landlord that I had, they were very consistent with this sort of attitude. So please don't think that it's just them. Don't think they're the bad guy. It's really an industry-wide problem. It's not just them. On September 7th, nevertheless, they attempted eviction, attempting to force pay for repairs of the air conditioner and oven. On September 18th, I filed a 30-day notice of intent to move out. On September 20th, I filed a complaint in the insurance case against Corazon Real Estate. Let's see here. There's no date here, so you can tell I forgot to fill this out. They acknowledged my move-out date. On September 25th, they were personally served with the complaint in this case, which is good. On October 3rd, they were served notice regarding the October rent, and then this notice regarding the destruction of evidence. Again, guys, you should watch the video on the topic adverse inference rule to understand how that works. On October 8th, they nevertheless served a 5-day notice of unlawful detainer for non-payment. Anyway, argument: temporary restraining order appropriate when facing irreparable injury. So I'm not sure. Okay, yeah, it's true. Let me talk about this really quickly because this is talked about in detail in the other videos. The courts feel that the proper way to deal with any kind of injury is to give you money for it. There are some situations where they have decided that money is not good enough. And those particular situations are situations that they call irreparable harm. And the definition of irreparable harm is not what you feel personally. It's defined in case law. And if it's not irreparable harm as the court has defined it, then you can't use an injunction. They don't want people getting injunctions willy-nilly. It creates all kinds of havoc. And it's also dealt with separately on appeal. So it creates issues for the Supreme Court and the Court of Appeals too. Because injunctions are one of the few things that you can appeal interlocutory. If you want to know more about what I mean by interlocutory as opposed to dispositive, watch my video on the topic filing an appeal. In Nevada, there's rules of appellate procedure that allow you to appeal these kinds of decisions even though the case is not closed. In any event, I still don't think that this was correct. I know that there's case law that says losing your home that you own is considered irreparable. I know that that's the case, but I'm not sure that that's true for renting. Maybe it is because people have families and their families may have kids that are going to a certain school and it's going to, cause all kinds of issues for the family besides just issues that can be solved by money. Maybe it is, but I would do a lot more research on it now. I mean, Alex from today would do more research than Alex from, I don't know, when is this, 2012? Just because I'm suspecting that maybe this doesn't apply to rentals. Anyway, let's move on. I contacted them regarding the ex parte motion prior to filing it by telephone and fax. This is required by the rules of civil procedure. Eviction of myself and the child would result in irreparable harm as it would be rendered. See, I don't think that this is good enough, the homeless rendering. I don't think that's what it is. I think it's I think what I read in case law was that it's something unique about homes that you can't just, people, yes, there's a price tag for every home out there, but there are certain unique qualities to a home that you just can't rectify with money. And so I'm still suspecting that this isn't a good enough reason. Plaintiff would likely prevail defending against summary eviction. This is, okay, yes, it is relevant. Whether or not you are likely to prevail is something that they do consider on giving you an injunction. I'm holding that the summary eviction proceeding was inappropriate. I needed only to raise a legal defense. So here I am challenging the justice of the peace's interpretation of this rule. This is true, I am right, but I don't think that this collateral attack on that decision is the way to go. It would have been, as I mentioned earlier, by appealing it, by following the normal appellate process. If you want to know more about what I'm talking about with that you only need to raise a legal defense to block an eviction, please watch my video on the topic summary eviction for non-payment of rent. I do have a video on this topic and I explain it. So yeah, this is a relevant case, but this is what would need to be discussed on appeal, not in this situation. So I'm talking about how what I just said earlier. You know, guys, watch my video on the topic summary eviction for non-payment of rent because this case law is relevant to that. Again, this case law also relevant to that. Hearing. It appearing that a hearing is required pursuant to Rule 65B. It would best conserve judicial resources to consolidate this hearing. Oh. Okay. I see what I'm trying to do. I'm trying to consolidate the summary eviction proceeding with the district court action. You know, I don't think that that's something I can do. I'm pretty sure that there is case law out there that does allow a landlord to proceed in the justice court on summary eviction and at the same time litigate in the district court. I'm pretty sure that this is not going to work. Well, it doesn't work. I already know it doesn't, but I'm just explaining why I'm pretty sure that I'm wrong. Conclusion, just requesting for an injunction. My declaration indicating this, all the facts alleged are true and correct under penalty of perjury. Certificate of Rule 5 service indicating this was mailed to the corporation. And by the way, I'm not going to redact any of this because this is official corporate stuff. I mean, this is not like an individual. It's an LLC and it's a full-blown real estate company. But please don't bother them about this. This is, ancient history. List of exhibits. We have 5 different exhibits. So yeah, I think I'm going to go through all 5 of these. They all look like they're pretty new. By the way, guys, I was thinking about covering the summary eviction proceedings, especially the hearing. I think that would have been really educational for you guys, but sadly, as I mentioned earlier, it wasn't recorded. And in the lower court, there isn't really a whole lot. There's the affidavit of tenant, and then there's the affidavit of landlord, and that's it. And now that I think about it, it's probably going to come up in these exhibits anyway, so you're going to get to see the affidavits anyway. The only thing that really would be left over is the hearing, which wasn't recorded. Exhibit 1. So let's see. I'm in receipt of their demand for maintenance of the air conditioner and stovetops. Pursuant to the law, it's your obligation as a landlord to maintain the appliances and the AC, which this is true. This is the law. Therefore, I request you remove the items from the bill. And then there's also 2 repairs needed. And then this is a process server or a friend. Exhibit 2. This is, I believe, a roommate. And what I'm probably doing here is just, it's just a potential witness. So line 3 and line 4 basically confirm the factual allegations that are made in the documents. And I just have a roommate who prepared an affidavit. Here we have 30-day notice of intent to vacate. This is, just indicating I'm intending to move out in writing. Here we have their move out instructions. So they're acknowledging the fact that I'm moving out. And then here we have, this is the notice of summary. Okay, so I've talked about this before. This is the notice that they post to your door to indicate that they're about to summary evict you, or evict you summarily. But yeah, I mean, this is what it looks like if you guys are wondering. Once you get one of these on your door, then you're supposed to respond by actually going to court and filing the affidavit of tenant. It's really backwards in this state. The person who actually opens the court case is the tenant, not the landlord. Well, if they're going to fight it. If there is no tenant's answer on file, then the landlord has a sort of backdoor way to open a court case, but it's not really opening a case. It's just kind of, I guess they call it a straight summary eviction. They do get a case number, but there's nothing really that needs to happen. The judge just signs an eviction for them, and that's it. It's not really a proceeding so much. I think that's everything. Yeah. Request for submission. Okay, you guys have seen 100 of these by now. If you want to know more about how these work, please watch my video on the topic, request for submission. Rule 5 certificate of service indicating this was also mailed to, oh, as you can see, it's to the resident agent. You know, I wonder if I've done a video on that. If I haven't explained resident agents yet, I may do a video on that to explain it to you guys. Going into the aftermath, I filed 2 documents. They were both free filings, so I incurred $0 in costs. Again, as I mentioned in my previous video, even though the landlord doesn't have an attorney yet, he will eventually get an attorney and they will eventually have to review these documents. So just so that things are organized a little bit better, I'm just going to go ahead and count the eventual amount of money that the attorney would spend in reviewing this. And I'm going to say 15 minutes for both at the rate of $250 an hour. That's going to come to $62.50 in attorney fees for the landlord. As my previous videos, feel free to post any questions you have down in the comments below, and I will see you guys next time.